How do I apply for an L-1 visa? If the employee meets the L-1 eligibility requirements, the employer will file a petition on his behalf with the USCIS on Form I-129. Adjudication of the petition can be expedited to 15 calendar days by paying a premium processing fee. Once USCIS approves the petition, if the employee is outside of the United States, will submit an application for a non-immigrant visa on Form DS-160. Next, he will pay the application fee and schedule an interview online with the appropriate U.S. Embassy or consulate. The whole process can be done in a month or less. If the employee is in the United States in another valid non-immigrant status, the approval of the Form I-129 will change your status to L-1. However, the next time the applicant wishes to travel, he or she will need to apply for an L-1 visa via the steps we described. Can I change from an L-1 to a green card holder? Yes. If you're an L-1A executive or manager, you may qualify for a green card in the employment-based first category, sometimes known as EB-1-3 or EB-1C. The EB-1C visa is an immigrant visa classification that closely resembles the L-1A visa. Because of the similarities between the L-1A visa and the EB-1C visa, it is a very common way for L-1 visa holders to go from an L-1 visa to green card. The petitioning green card employer must be a U.S. employer. The employer must have been doing business in the United States for at least 1 year as an affiliate, a subsidiary, or as the same corporation or other legal entity that employed you abroad as an executive or manager. Unfortunately, this green card category doesn't benefit L-1B specialized knowledge employees. They need to apply for a green card through the traditional labor certification process. Application process of going from L-1 visa to EB-1C green card. Going from an L-1 visa to an EB-1C green card is a two-step process. First, your immigration lawyer will file a Form I-140, also called the Immigration Petition for Alien Worker. Second, your immigration lawyer will file a Form I-485, also called the Application to Register Permanent Residence or Adjust Status. In many cases, your immigration lawyer can file both of these forms concurrently. There are other options to go from L-1 visa to green card. L-1 holders can be eligible for a green card by having a U.S. employer sponsor through a job offer in either the EB-2 or EB-3 visa categories. In order to do this, the U.S. employer will have to get an approved labor certification. A labor certification is issued through the United States Department of Labor and certifies that the U.S. employer made attempts to hire a qualified U.S. worker but was unable to do so. Another option to go from an L-1 visa to green card is through the EB-5 visa. In order to get an EB-5 visa, L-1 holders must invest $1,050,000 in a U.S. business, and the business must create 10 full-time jobs for U.S. workers. If the business is located in a TEA area, may qualify to make a reduced investment of $800,000 instead of $1,050,000. In summary, if the applicant meets the requirements, the L-1 classification can be a relatively easy way to work temporarily in the United States. The L-1 category has no annual quota and it often has a clear path to permanent residency. Continue watching our videos for further information.